Welcome to our seminar on Certificates of Formation. This is part of the C.I.A. Services Association's in Practice series of videos. In these, we break down important topics into practical, easy to understand insights for community volunteers like you. My name is Ralph Troiano, and I'm pleased to be sharing this information. Our company's been managing community associations in Texas since 1984. Let's look at the topics for this video. What is a certificate of formation? Who prepares it? Where is it filed? What's in the certificate? How can it be amended? And how does this particular document fit in with other association documents? Let's get started. First of all, the certificate of formation is what creates the association as a legal entity under Texas law. It's the same thing that creates all corporations in Texas, whether it be a for-profit corporation or a not-for-profit corporation. It basically defines the purpose and the powers of the association. Prior to 2006, this document was called Articles of Incorporation. So if you're an older association that was created before 2006, the document you have is called Articles of Incorporation. For a property owners association, the certificate is prepared by the original developer to establish the association, whether it be a property owners association or condominium association. It's typically prepared early in the development process to reserve the association name. The developer may want a particular name for marketing purposes, and they need to register by creating this corporation with the state of Texas. And in addition, that name will be needed to be in the deed restrictions and bylaws when those are created. The certificate is filed with the Texas Secretary of State's office. There's a nominal filing fee, and the certificate must be filed before the association can begin operating. Although it's not optimal, sometimes it's not created until after the developer starts selling lots and homes are built in the community. Separately from registering that association with the state of Texas, this new corporation must obtain a federal tax ID from the IRS before any financial transactions can occur. So what's in the certificate? Well, Texas provides a simple 3-page online form for creating a nonprofit corporation. It's pretty easy to fill it out online, press submit, and a few days later you will get confirmation from the Secretary of State that your new corporation has been registered with the state of Texas. That standard form has name, registered agent, board members, a brief description of the purpose, and a few other details. The registered agent, for your information, is the individual or corporation who would receive any notices from the Secretary of State if they need to communicate for you. And importantly, if the corporation is sued, that is who gets service on the lawsuit. So the lawsuit papers are served upon the registered agent. Now, even though there's a standard form that's easy to fill out, most developers opt to create a more comprehensive certificate. That would include a little bit more detail about the purpose. It would list the association powers, maybe membership, voting rights, indemnification of directors, and a method of amendment. All of those things are optional from the state of Texas standpoint, but they're useful for the association's continuing operation. How would you amend it? Well, first of all, there are a few reasons to amend the certificate. You don't need to amend it when the board members change. The certificate only indicates the initial directors. The purpose probably won't change. And so, again, there are a few reasons to amend it. If the document does have amendment language, there actually is generally a pretty high consent requirement, maybe 75% of all members. However, if you use the standard form by the state, which doesn't have any amendment language, then the Texas Nonprofit Corporations Act addresses amendments to articles of incorporation or certificates of formation. And that says, if you want to amend that document, consent is needed from 2/3 of the members at a meeting called for this purpose at which a quorum is present. There are many documents and laws affecting how an association operates. And the question comes up as to how you handle a conflict where two documents say two conflicting things. Well, that's the concept of precedence. For an association's documents, if they're well crafted, then there should be few conflicts since each document really has its own purpose. So for example, if you want to deal with an owner's obligation to maintain their home, you'd put that in the declaration, not in the certificate of formation. If you want to deal with voting, well, that goes in the bylaws, not in policies or procedures. So if there is a conflict, and they do come up, especially between maybe Texas law and the declaration or Texas law and the bylaws, this chart shows precedence. So federal law takes precedence over state law. State law takes precedence over our declaration, which takes precedence over the certificate, over the bylaws, and all of those over any policies, procedures, rules, and regulations. Well, thank you for watching. We really hope the seminar provided valuable insights to you. Be sure to check out more topics on our Associations and Practice series on our YouTube channel.